9, 8, 7, 6, 5, 3, 2, 1, 0, and liftoff.
Hello, I'm Andrew Myers, here with About the Law. We're about ready to see what we think is the final motions hearing in the Sarah Boone case. And, we are in the court in Orlando, or we're going to be watching. I'm here in my conference room in my law office, but we're going to be watching the Sara Boone motion hearing. Welcome. Okay. Lainey is going to be here with me today. Unlike the last live we did, she was unavailable. She just texted me, I'll be there in a minute. So she'll be with us. One of the things that we are going to hear today is a motion to suppress. And here it is, the amended motion to suppress the defendant's statement in court. And let me bring up your comments because I know there were some questions. Louise Powell was here earlier before we went on stream, and she asked, are these the last of the motions yet? We think so. The judge last week in the last hearing that had been delayed by Hurricane Helene had said, you got to file all your motions by midnight on the 29th. And, sure enough, this motion here was filed. Let's check the date stamp here. 9:30 at 4:39:33. So a little bit after 4:30 on Monday of this week. So that got in just under the deadline. Dog Mom, welcome. I'm glad you got here on time too. You're early. These things generally don't go on time, but you never know. And then Tina B. Hey, good to see you, Tina B. Good to see you. So among the things that'll be argued today include Sarah Boone's motion to appear in street clothes. And her attorney says he would be somebody from his office, obviously, would be taking measurements. The motion for her to have makeup and hair. But this is the substantive motion that's on the books for today. Amended motion to suppress the defendant's statement. So as I believe most people that have followed the case, on about February 24th of 2020, the defendant called 911 in response to finding boyfriend George Torres deceased. And Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. Upon arrival, Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her superiors and secured the scene. So this motion goes on for several pages. We may or may not have time to go through much of it because I've got to keep my eye on the court. 5 minutes on the countdown to the court hearing. So we'll keep going here and see that number 4, sometime later, homicide investigators Chelsea Connolly, a.k.a. Chelsea Kopsel, and Scott Lowen arrived. These two investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the Orange County Sheriff's Office. From now on, we'll just say OCSO, okay? The defendant, Sarah Boone, was ordered to remain on scene while the sheriff conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. At some point, the defendant was told to get into an unmarked vehicle with Detective Kopsel and Detective Lowen. Once inside, Detective Kopsel recorded an interrogation with the defendant after partially reading her Miranda rights. Now, this is the issue. Did they partially read her Miranda rights or did they properly Mirandize her? Attorney Owens says here in parentheses, omitting the final question. The defendant was advised this recorded interrogation was routine protocol and official procedure for any death investigation. Okay, we're picking up steam here. Tina B, hey. Dog mom, truly, this is not a G. This is not her walking down the red carpet. She is delusional. Dog mom, she has horrendous case of self-entitlement. Well, I mean, let's keep reading the motion. During the investigation, Detective Copsall asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen floor. No, I read that wrong. Her phone was on the kitchen counter in her apartment. That's where I keep mine. The detective brought the defendant her phone and instructed the defendant to unlock it. The defendant complied with the demands of the lead investigator. So she willingly gave the phone over with consent, and she willingly unlocked the phone with consent. Paragraph 8. After Detective Copsall had the defendant's phone for a period of time, she came back and told the defendant she was taking her phone. Detective Copsall asked the defendant to sign a form releasing it to the sheriff's department for further investigation. The defendant acquiesced authority and signed the form. So she signs over her phone. And from the way this reads, it sounds like Sarah Boone consented to giving the phone to the police. Interesting, because we all know it was on the phone. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copsall on her cell phone to express her concern that Detective Copsall was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed they were trying to trick her and being sneaky about something. Okay, we are T-minus 2 minutes to the hearing, if it starts on time. I'm just monitoring that and trying to read this motion. And we have Lainey Law is joining us. Look at that. Lainey Law is now joining us.
Hello. Okay, sorry. I had your stream up. I was switching between tabs. Hello, everybody. How's it going over here?
We have 4 whole people watching us, but I'm encouraging them to share this and call all their friends. I am hoping that we'll have more than 4 people this afternoon. I know it's a very heavily watched matter because the trial is scheduled to start next Monday, the 7th, which doesn't give people a lot of time.
I'm just checking real quick just to make sure that my audio to our dear 4 people before I force Andrew to stop looking at the viewer count, I'll smack ya. I want to make sure my audio is not too loud. I think I might be.
Okay, we have the court. The court just opened up. We see the bench, Judge Michael Kranick. We're looking at the bench. He's not out yet, so let me laboriously, as you know, I will bring it up. I assure people they will not miss a thing. You're not going to miss a thing, but I'm going to take down the motion, and I am going. The judge isn't out. They've just turned the camera on, and when we see an empty bench, there's no judge sitting there. We see the flag of the United States of America, and we see the flag of Florida, and we see nothing. Hang on. Not missing anything. Not missing anything yet. Not missing anything yet.
I see Yoli's in chat. Hello, Yoli.
Yoli's in. Hi, Yoli.
We have 4 special people. I agree with that, Majestic. Thank you.
Now, wait a minute. I'm having trouble presenting. Slides, extra camera, video file. I did this before, so what the hell's my problem? Oh, here we go. Here we go.
Da, 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 da.
Okay, here we go. So,
did you?
Yes,
is there any audio playing right now?
No. They're not. No. The court's not started yet. No.
I'm on the edge of my seat right
now. The
judge
isn't out yet. We just seal the great state of Florida. Hi, Yoli. Yoli, do you want to join us?
Yoli, pop in. I feel bad. I know she's been busy lately.
Yeah.
Oh, I see an arm. I'm like, I'm like sitting here. It's just like, what's going on?
Yoli, I'm going to invite you. You can come in if you want. You don't have to if you don't want to, because I know you're a busy person. I know you have a lot of stuff going on right now, but I'm going to send you an invite anyhow. So let's see. See, I'm getting good
Let's
at this
invite
stuff.
the rest of the 4 people.
Just before the whole thing crashes, he says, "I'm getting good at this."
So
So
far,
I
I
should.
mean, everything looks very smooth. I'm very impressed. We have our
Okay, so I invited you. You don't have to come in if you don't want to, but all right. So the camera's moving around. That means that there's some life in the courtroom, and we are in the courtroom now.
so it's
And
scheduled to start at 3.
yeah, which is an unusual time. Usually, well, it can happen at any time. I've had motions hearings, generally 10 and 2, 10 o'clock, because it gives people time to wake up, get into court early, and talk to opposing counsel, talk to your client, conference the thing, get your mindset for 10. Then 2, obviously, you have time for lunch and come back and do the same preparation that you need to do. But yes, I am experienced in having all kinds of crazy times. Maybe the judge scheduled it for 3 as a warning to the parties that they didn't really want to mess around with pushing a long hearing. Like we had a long hearing in the Koberger case back when they were arguing the change of venue, and they had multiple experts, and that was a long hearing. But I think the judge was saying to them, by doing it this way, guys, it's late afternoon, we're not going to be here forever, so who knows.
So I guess my question, like you say that, do you think that it's because we've seen also some really, really short hearings too?
Yeah.
Do you think that it's going to be going for the full hour? Do you think that do you think they're going to try to push this out like as soon as possible?
I think they're going to use at least an hour because, hey, look, Rosie's here too. Hi, Rosie. How are you? Good to see you. You remember Rosie?
Yeah, we did a episode with Rosie.
Yeah, and then I did a Rosie invited me to do something with her a couple of weeks ago, and we did something on the crazy Sandra Birchmore case. Yoli can't come on panel right now. I'm catching up on things since I was in trial. I'll be back to normal hopefully by the end of the week. We understand, Yoli, but it's good to have you here. We appreciate your comments. I'm going to invite Rosie too. I understand if you can't come in, Rosie, because I know that you're busy. I know that it's
I was going to say late too.
It's 9 o'clock where you are, so it's late there. That's okay.
Oh.
I'm going to invite
9
you. If you
o'clock is not too bad.
What?
I said 9's not too bad, but it's still so crazy. It's 3 p.m. over here.
I think Rosie had some exams or something, though.
Oh my gosh. Yeah, the semester. I don't know if Rosie's in college, but my school semester has just started picking up hardcore. Got like 3 tests next week.
Yeah, that's the attorney right there, James Owens, walking back and forth. So, they set up these hearings for a certain time. Sometimes they don't start right on time because the judge is, going over the motions. We started reading it before, or sometimes he's conferencing things in chambers. A lot of times the judges will call us into chambers and say, all right, what's the real issue? What is this all about? They don't come right out and say, what is this BS? But they will say, as I see it, Attorney Myers, the issue is this. As I see it, Laney Law, the issue is that. Now, are you two ready to argue that? I mean, they'll prompt us a little bit and tell us. So, I don't know. I don't think that's happening because I see Attorney Owens walking back and forth.
I'm hoping that the audio will be decent this time because we've been experiencing a lot of court cases where it seems like the YouTube streams end up being very low.
Yeah. Yeah, that's true. The one we did last week in the case that we did last week was the audio was low. So I don't know. We'll just see. We'll punt. That's what they say. We'll punt. So I don't know if I should go back to reading the motion because as soon as I go back to reading the motion, essentially the issue that Attorney Owens is raising, he wants to suppress the 2-hour hearing. I'm sorry. He wants to suppress the 2-hour statement that Sara Boone gave to the police detectives in which she pretty much cooked her goose. And he wants to suppress it on the grounds that he claims that they didn't read the entire Miranda warning. Now, if you read it along, they did not read every single word on the card that Owens has. He doesn't have the Osceola County Miranda card, but he does have a similar card that other law enforcement uses, and they didn't read exactly, but the issue is, do they really have to? And then the final sentence on the card is, do you understand what I just said? And do you knowingly waive that right? Now, the police did say, do you understand? But they didn't take that final step. So he is saying that based on the fact that they didn't read the final thing on the card, the whole thing should be thrown out.
Have you heard of anything like that? That's not something that's ever been an issue before, right?
Well, the interesting thing about the motion is that there's not a single case that is cited. Now, when I write a motion, when any attorney who does litigation writes a motion to the court, as my civil procedure teacher taught me all those years ago, and it applies in criminal court just as much, you're literally moving the court. A motion is something that literally moves the court, and you need to cite authority. If I say, I don't think my client was properly Mirandized, I need to provide citation of authority, mandatory authority. Really, you can have informative authority, but you really need to say, here's what the United States Supreme Court has said, or in the Sarah Boone case, here's what the Florida Supreme Court has said. So to do a motion, and we all know that he's under a lot of pressure. He was only brought into the case in the last day of August. So he doesn't have the time to really do all of that. But in any event, he did not cite one single case. And so your question, is this usual? That's a question this judge, I would guess, is going to ask. So
I'm curious too, because this is a relatively new issue that we're encountering too, because of, I'm assuming, cop cameras. So I don't know how this is. I don't know if not reading the whole thing necessarily throws it all out or what. I can't imagine the judge really caring about it.
It's a small point. It's a small point.
Yeah.
I mean, if it were my case, I would have done some research and found some case law that goes my way, because now the prosecution has had since the 30th. That's only 2 days, but they have had 2 days, and I assume they've had paralegals and interns that can go research the law. So, I mean, that should be made clear to the judge. I mean, Rosie can't join us, and I understand because it's late night over there, but Rosie, it's good to have you with us. Louise Powell says it's 8 p.m. here. Wonders of modern technology. Can't wait for this trial to begin. Hi, Lainey and Andrew. So thank you, Louise Powell. We appreciate you.
Do you think that this hearing could be used, like, because we were talking about how he hasn't even been on the case this long? Do you think that there's some way that he can kind of leverage this hearing as a way to kind of buy more time?
The judge has been very clear on this. The judge has said
the judge has been over this.
She's been through 8 attorneys. It's been 4 years. George Torres, the date of death was February 25th of 2020. That was the date that they found out about it.
What a crazy year.
So it's been 4 years. And to put that into perspective, February of 2020, it was the last normal month before the pandemic hit.
That's what I was thinking. It's like, but even like, I feel like from January, even counting January, I feel like things were completely off that year. It's just, but it's actually kind of interesting to put it that way, because it was a month before everything got really crazy with the pandemic. Even though it was 2020, it's not any out of normal, stressors and stuff like that. It's not like, oh, COVID happened, she went crazy. It's like before that.
No, it happened right before the pandemic. But that puts it into perspective. So to answer your question, will the judge take pity on James Owens, the new defense attorney who's only been on the case for just over a month now? And will he take pity on him and give him some more time? Based on what the judge has said to date, I doubt it. But folks, I took the camera down because nothing is happening. This is scheduled to be the final motions hearing before Boone's trial on October 7th, which is Monday, which is only, 5 days from now? 3 if you don't count the weekend. So,
It's crazy that he would even pick up this case. That, I think if his reasoning is true and that it's for noble reasons, it's, admirable. But at the same time, to do something so last minute with such a big case with such a long history is kind of crazy.
Yeah. I am watching the courtroom, and we're still just seeing the bench and the 2 flags, the great seal of the state of Florida. I'm seeing the American flag, and I'm seeing the state of Florida flag, and I'm seeing the brass plaque for Michael Kranick and an empty chair behind it. So if anybody has questions, I know a lot of people have had questions about this case.
Yoli actually has one right now.
What?
Yoli was asking, is Sarah Boone claiming she was abused and this was self-defense, which I don't know if it necessarily came from Sarah Boone, but that was what her defense was saying, was the battered spouse.
Yes, that was a controversial issue, and the court will allow her to use battered spouse syndrome. And so as a result of that, and the fact that reluctantly the court allowed her expert, the state of Florida is going to be allowed to have their expert interview Sarah Boone. And yes, she will use BSS, battered spouse syndrome, even though they weren't married. That's the name of the syndrome. It should be battered person syndrome. But yeah, so yes, Yoli, yes, that was an issue in the last hearing, not the last one on the 27th, but the one previous to that. The judge said, you can't say that it was an accident and say that it was a battered spouse syndrome, because battered spouse syndrome is an affirmative defense, which means you're saying basically, yeah, I'm guilty, but I had a defense against doing it. So it's one or the other. And the judge kept pushing Attorney Owens, and Attorney Owens finally said, yes, I'm saying it wasn't an accident. And the judge said, well, I haven't heard those words come out of your mouth. I have not heard those words come out of your mouth. So that's the first time that was said. So,
oh my God. Do you think that's going to help or hurt it? I don't know, because I guess my thought with saying that it was an accident or whatever, that maybe it could be like lowered to a degree, but then if you're doing battered spouse, then it's either it is or it isn't. Then I feel like that's more of a risky play.
How does she get around that video where she sounds, her words were slurred? I'm sorry. Her words were slurred, and we all know what that means. Even a non-expert can offer an opinion about intoxication. And Mr. Torres was saying repeatedly, Sarah, I can't breathe. Sarah, I can't breathe. And she was saying, well, how do you feel? That's how I feel when you cheated on me. So how does she get around that?
I don't know. Just like having the video is so crazy, because like you can't even like do really 2 things at once and take a video. I'm sure, as everybody's here. I have a video the other day where I was playing with my dog and the dog starts running out inappropriately, and it's like the video is like completely falling apart. It's like, to be able to pull out your camera and take a steady video, especially like for an extended period, you're just chilling there. You're not like, you can't really say that you're threatened at that point. So much time had passed. And with the battered spouse, it's like, at the same time, it's just like, if you locked him in a suitcase, you could call the cops if you were that concerned. But they had so many issues with the cops back and forth, where I feel like no other option. There's no audio right now, right?
No, there's nothing. And Dog Mom makes a good point, because she says, I remember watching this from the very beginning, and all she ever uttered was unintentional. Yeah, she said it was an accident. Her original story was, we were playing hide and seek. No. But she said that she zipped him in the suitcase and she fell asleep. We all know what happened. She passed out. So her original story, Dog Mom, you are correctamundo, that her original story was, it was unintentional. It was an accident. She didn't mean to leave him in there. But, how is a jury going to believe that when, we have George, clearly saying, I can't breathe.
And Yoli brought up diminished capacity, saying if she was under the influence, but that
No, because
comes.
Florida has a
Mhm.
statute that does not allow use of alcohol to be injected as a defense. So, Yoli, that's a good point in other states, not Florida. There's one of our previous commenters had corrected me when I made that point. I said maybe she should claim diminished capacity if she was drunk or on drugs, and one of our commenters corrected me, and I looked it up, and I said, I've told people before that I'm only an attorney and licensed in Massachusetts and New Hampshire. Florida has some specific statutes on that. And so, no, that's why she defaulted then over to the battered spouse.
Yeah. I feel like Florida has too many Florida man stories. That's why they can't do the diminished capacity. It's like all the craziest stories you hear are someone under the influence in Florida, seemingly.
There's no audio yet, and I'm hoping we get some audio, but there's no audio net. You're seeing live what we're getting from the stream. You're seeing live what we're getting. The bailiffs are out. The camera went out to a wide shot. The stenographer's there, ready to go. But so
are they like, and for example, in Massachusetts or New Hampshire, if court says it's going to start at this time, is it usually on time?
Yeah. New Hampshire more than Massachusetts. New Hampshire, some of the courts, I go to Rockingham County, they run that place like, well, they used to run a train station. If they say your hearing is at 2:10, you better be there at 2:09. Because if you're not, the bailiff is coming out of the hallway. Danny Myers! Danny Myers! So you better. The Mass courts.
They're on island time, the Mass courts.
Although I told the story only one time in all these years of practicing law, I was a couple of minutes late for the Newton District Court in Newton, Massachusetts, because parking is impossible. And I missed the call of the list, and they dismissed my case because I was a couple of minutes late. And I went over and I talked to the clerk. I said, look, come on. And he said, oh, no, you have to file a motion. So because I was a couple of minutes late, and I don't think most courts do that, but the Newton District Court did in Massachusetts, I had to file a motion. I had to go argue the motion, and then I had to go back for the hearing. So,
my God,
that's very unusual. Very, 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 very unusual. So the answer to your question is you got to know your court. You got to know your court. It's not unusual for them to be late because, as I had explained earlier, sometimes the judge wants to talk to the parties. He calls them in and he wants to review stuff and focus down on what. There's Sarah coming in. They're bringing Sarah in, and she's shackled, and she has her Department of Corrections, dark blue uniform on.
I have a question. When they came in, they made her stop for a second, it seemed, in front of the camera. I don't know if you caught that. What? Was there any reason you think for that, or no?
Who knows? Was it intentional? Was it unintentional? Dog Mom is from Pennsylvania. I'm from Pennsylvania, Dog Mom. I haven't lived there for many years, but Dog Mom is from Pennsylvania. Welcome. Dog Mom is a paralegal for the better part of 25 years and only for prosecutors. Okay. All right. That's fine. A lot of people, work both sides.
Bring Dog Mom to New Hampshire. Have her be your new paralegal.
Yeah. Yeah, I do need a new paralegal. If anybody out there, wants to. And we train. We do train.
I'll talk to you after. I actually have someone for you.
But somebody that knows prosecution would certainly be able to jump ship and do defense. Not that I'm suggesting that to anybody, but if you know the prosecution side, you can effectively, understand the defense because you know where the weaknesses are in a case, and how defense attorneys over the years have poked holes in them. And I do mostly plaintiff's personal injury work, but I've done a little bit of defense. And I think I do well when I do defense because I know where the holes are in a case, and I know how to poke holes, and I know how to argue them. But so Sarah's out. She's
Is this
sitting
just like a
at,
general briefing?
who knows?
Like she's being
The
cut off
judge
and you
might be
can't tell.
inside, just reviewing the pleadings because before you came in, Laney, I was going through that motion. The prime issue this afternoon is, will the court suppress a 2-hour statement that was given to Sarah? And Attorney Owens is claiming that she was not properly Mirandized. But it appears that, they read 99.9% of what was on a card that Owens placed in the motion. So that is an interesting issue.
So they just zoomed in, but I thought it was because about the point that I was about to make. With the Koberger case, I think it was that they were really picky about the cameras not catching any of the paperwork and stuff. I'm noticing that we're getting a live stream of this person's laptop, and all these papers.
But you know
Obviously,
what?
yeah.
You know what? Can you read what's on those papers? Can you see what's on his laptop? I mean, I thought that was a spurious thing that was said by that judge, and I said it less forcefully then, but I think that was a stupid thing by the judge because you know what? Can you see what's on those papers? No, of course not. Can you see what's on that computer screen?
No, no. Well, I can't see it right now, but if he pulls up Facebook, we're going to be a little suspicious. I think some things will be able to tell what he's doing, but
yeah, if he starts checking, but no, you can't see what's on that screen. There's no way. But yeah, the I think Attorney William Thompson had made that argument, although maybe Ann Taylor did. Now I don't remember who made the argument. I thought it was a stupid argument. I really did. Because, even now they're going to go in closer. Sarah's getting talking to by her attorney.
We need a professional lip reader.
Huh?
We need a professional lip reader.
Yeah. Yeah. But you can't tell what he's saying, and you can't see what's on those papers, and you can't see what's on that computer screen. It looks like a document. Looks like a Word document because what do you call that little screen, that little part of the screen on the left where you can type in functions?
I'm not sure. Oh, I know what you mean.
The sidebar? No.
Yeah. Yeah. Oh, that's probably you know what? You're right. He's probably like all these papers they have in front. He just has all the documents on his computer right now. It looks like that might have been okay. So now this is the problem of them filming and not getting to this case right now, because now we're just like, okay, well, he was looking at the hearing document seemingly. It's just like now I can start identifying what it is. It's like you have a page there, and then the top right is like the address, and then it's got that bold text towards the bottom.
Yeah, but it could be a document in this case, or he might be writing a letter to his girlfriend. You can't see what it is.
Yeah, I mean, I don't think it's that serious. I just thought that was so interesting that we have like such a view after having it be an issue in the other cases. Oh, they disabled chat. I was like wondering how on earth they were going to keep chat civil. They did not even bother. They knew their limitations.
Hey, look, Dog Mom says, I would love to jump to Massachusetts and be your paralegal. We're Pennsylvanians after all.
There you go.
And then Yoli says, yeah, it does look like a Word document. She agrees.
Yeah, we want to know. We want the deets.
Yeah, so I mean, yeah, they're just looking at stuff. Sarah's looking down at some sort of a document. Who knows? Maybe she hadn't seen the motion that I was reading before, and Dog Mom says, notice how she stopped writing the notes and letters to the judge. Dog Mom, you know why that is. Any defense attorney that's taken criminal law 101 in law school knows the first thing you tell a client is don't say anything. All comments will come through me. And I'm sure James Owens, being an extremely experienced criminal defense attorney in Florida, I'm sure he told her, listen, your calligraphy skills are very good. That was a very nice ad you did, but no more.
Oh, that ad was beautiful. That ad, I will say, despite the language used in it, the graphic design was beautiful.
Look at Yoli. She's accused me of being nosy.
Yeah. It's like we have this whole channel is based on the premise of being nosy.
Well,
The
I was a
backbones of
journalist.
our society.
I was a reporter for 10 years. I mean, it wasn't that my job. Then I get
Yeah.
paid to be nosy. I mean, I could read upside down. And our former assistant here, Ron, who was my cameraman when I was a reporter, can tell a funny story, which I refuse to tell, about how I was reading a certain mayor's papers upside down on his desk when the mayor left for a couple of minutes. So yeah,
My
I'm
life.
nosy. And you read stuff upside down, and you get documents however you can get them. And but Yoli, you can't, you cannot. You can see that it's a Word document on the computer, but you can't tell what it is. I mean, even if you blew that up a million times, you can't really read the document, I don't think. And if you can, I don't know. Anyhow. So we're still waiting. We're 27 minutes in, and I'm watching on another monitor too. And both monitors have the same picture. So we're just waiting. We're waiting for Judge Cranick. Maybe it's like a football game, and Judge Cranick is running the clock because he really doesn't want this to go that long. I don't know if Florida is like a lot of courts. The staff leaves at a certain time.
That's what I was just about to look up.
Unlike in the Ashley Benefield case where they kept the jury till 11 o'clock at night, most courts, they'll keep going if it's being productive, if arguments are being made or the jury is making progress. But most courts, 4:30, 5 o'clock, hey, the staff has to leave. The people that keep the lights on, the people that sweep the floors. This is all important stuff to keep, people that keep the lights on, people that keep the air conditioning going, they're important people. Because without them, how can you sit in a stuffy, dark courtroom? So anyhow.
I did look it up, and it looks like they usually close around 4:30, 5 o'clock. So
oh yeah.
Yeah.
So the clock is being run here.
Are there going to be, so there's going to be two arguments, like they're both going to be able to provide their arguments here?
Well, the more they run the clock, the less time they have to run their arguments. That's the central issue, really. The central issue really is, will this statement be suppressed? And I'm not one to give odds, but I really wouldn't. Just looking at the motion, it doesn't look great.
Mm-hmm.
Louise Powell says Judge Cranick is hiding from Sarah. Come on now. She's shackled. And look, Dog Mom does not like that calligraphy. She says, you can obviously tell my severe disdain for Sarah, but I think her ad looks like a Barnum and Bailey advertisement. I didn't see any clowns. I didn't see any clowns. I didn't see any tigers. I actually used to know a vice president of Barnum and Bailey many years ago. Yeah, he was in charge of making arrangements for marching the elephants down the street in Boston when the circus came to town.
Oh my God.
Somebody actually has that job, and he was at that time a vice president. Anyhow.
I want that job. That's like, I went to the aquarium the other day and somebody was feeding the penguins, and I'm like, what are the requirements for that to be surrounded by penguins all day?
Who did I know that got a job at the Boston Aquarium? I knew somebody that got a job, and she was extremely excited. I can't remember who it was now. Might have been probably a former paralegal. Girl. What? I think it might have been a former paralegal. I think it was, and I think you know her too. I think Okay, we've got sound. No more stupid stories. Can everybody hear that?
Sound? We can't hear it right now.
You can't hear it?
No, go back to the way that you shared it, and you might have to go in StreamYards and make sure that the
sound.
audio.
We have sound.
It's on StreamYards, the sound issue.
What do I have to do?
Go to StreamYards and remove what we're seeing right now.
Yeah.
When you get rid of the stream, you're gonna have to re-add it, and when you re-add it, you do the tab and then you share tab audio.
Yeah, now what?
Get rid of the source. So like remove that whole thing. I can still see that it exists. It's just not up. So now
Yeah.
add it again. And when you add it, before you add it, make sure that the box is ticked off on the bottom that says share audio.
I have news for you. It says also share tab audio, and that was on.
Uh-oh.
Hang on. Let me try something else.
Well, did you click it? Because it says it on the bottom, but you have to add it. Now it's working.
We've got
You hear it?
outside
Yeah.
to testify. We've
Okay.
also got the
Sorry,
custodian
folks.
records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Something else? Did you actually a Miranda card?
Yeah, if you look in the very back,
No, that's cute. They're working together.
if you look in the very back,
You hear it okay, Lainey?
Yeah.
Okay.
Well, right now it's a little quiet, but I think that's just them
Yeah.
because they're not talking in the mics.
Of our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records? Yes.
Okay.
So now with the wanting to appear in
I also
normal
have reviewed
attire,
the
is that?
2 hour and 6 minute
I'll give them a second.
investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, state, you may proceed.
Uh-oh.
They would ask the clerk to mark A for identification as a DVD, courtesy copy, body worn camera.
Yeah, when they walk away from the microphones, the audio goes down. They've got
Yeah.
microphones at the table, and the judge has a microphone, but as soon as they walk away from those, there's no overall pool mic, flood mic.
But
I
why
have
did
reviewed
he get
all of
up?
them
Oh.
in advance of today's hearing.
To present a DVD to the court clerk.
Oh.
Any objections?
no objection.
What was pre-marked as states A will be received into evidence without objection as states 1.
I presume that's the DVD that has the 2-hour statement by Sarah Boone that they're trying to suppress.
Mhm. Now they were trying to argue that she could wear civilian attire. Is there any reason, like, is it just the prosecution wouldn't want to allow that because they don't want her? I don't know, because I feel like by coming in prison attire, that almost creates bias.
It does. There's a Supreme Court
Yeah.
case that says exactly what you
Good
just
afternoon,
said.
ma'am. Could you state your full name for the record and spell it for us?
Chelsea Castle, Chelsey. Last name is K-O-E.
She was one of the people that interrogated Sarah early on.
Thank you.
Chelsea.
Where do you work, ma'am?
Mhm.
Sheriff's Office.
And what do you do for Sheriff Mina?
I
How long have you been a homicide detective?
am 6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
Here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it was more just to like introduce myself and to let her know, we're doing a search warrant and procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes, 2 or 3 minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked path color. Didn't look like it. Didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lone sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any
The
way
situation.
unusual to gather evidence before talking to the last person to see a decedent alive? At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
Yeah, in the motion that we read a little while ago, the attorney had pointed out, even her own attorney admits that she authorized her, this police officer, to go ahead, or the sheriff's deputy, to go in and pick it up. So there's really no argument that they can't have the phone. That I see, Sarah Boone authorized her to go in and pick it up, at least initially.
But does that give permission
All right.
to look through it?
And ultimately,
I'm sorry, what'd you say?
That she can take it after that, just from that?
Only if there's consent. Yeah. Oh, by the way, for our viewers at home, I'm in Studio A in my conference room, and Lainey's in Studio B, which is distant. So we're not in the same place like we usually are. So that's why we're having a little bit of a communication. But yeah, they can't just seize something unless they do have a warrant for that specific item or with consent.
was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Not go back in her house.
Prior to that, had she been detained and requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay.
This is why you always prepare a witness, and no, it's not bad. You can't tell them what to say. That's coaching. But you usually prepare a witness. You go through the report and say, okay, what time did you do this? Did you do what with the sequence of events? It is not coaching to review testimony. It is coaching to tell a witness what to do. So I don't know. I just don't think that this witness was prepared.
Yeah, because they were like, do you remember what you asked her? And she was just like, no. Like she didn't know what they were talking about.
Yeah, this isn't going in as smoothly as it should. Not that it makes a substantive difference, but it's just sloppy.
February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there? You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
Objection, leading the witness.
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment. And so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have
It's a room with a table.
that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes.
Did we really get anything from that? I don't know.
I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that
Eric.
Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. but due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to search in the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is,
Yeah, I have to agree with our commenter who said that, you would have thought that she would have refreshed her memory on some of these, details. I mean, she was the prime investigator at that time. She's mentioned in the motion that was filed a couple of days ago to suppress. So you would have thought she would have been better prepared. I mean, usually, a judge is going to want the testimony to go in more smoothly than it is. Not that that's really going to make a substantive difference, but it might, because some of her testimony is not directly lining up with what was in James Owens's motion.
Well, I was going to say, you mentioned before that they should have briefed her on this. Is my main thought is that it seems like she's just kind of like trying her best to recall this and didn't seem to.
It's okay for a police officer to review their police report, because the police report is going to come in anyhow, likely, not always, but I mean it's common for a police officer to review, or in this case a sheriff's deputy, review their reports beforehand, and that way the testimony just goes in more smoothly. And because if they don't testify totally in agreement with the report, they're going to be impeached with the report. So, when I go to court often, a busy court like a district court where there's a lot of criminal defense work going on, you actually see police officers walking around outside in the hallway looking at their police reports. So, and this is not like a little case. Is yeah, it should be in there. It's certainly, I interviewed her here. I got in the car. She got in the car. I then talked to her. Yeah, that would, yeah.
Mhm.
That
Okay.
you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes. Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay.
I kind of agree with the comment that was just made that that this is all a lot of fluff. This defense attorney has nothing. He's not going to get anything stricken. I would tend to agree with that. But on the other hand, all attorneys have a duty to represent their client zealously. And I learned early on that in a case, in almost any criminal case, if you do not bring motions to suppress and you do not bring motions in limine to exclude evidence, that's ineffective assistance of counsel. So, I think a lot of us don't think that this motion to suppress is going to be successful, and a lot of us don't particularly care for the way these questions are being asked and answered. He's got to do it. It's his job, and he's not doing his due diligence. I mean, if you were accused of a crime and you had an attorney representing you, it's his job, and you would want him to do all of this. It's a requirement. As tedious as it is, it's a legal requirement, it's an ethical requirement.
That's a really good thing for you to point out, because as I'm watching this, I'm sitting here like, oh my God, are we even getting anything from this? What is the point? But you make a great point where he's just doing his job. This is just, he has to do as much as he can.
You got to do it. And I've done motions like this in cases, and I've had judges kind of look at me and they know that I'm doing my due diligence. And when it's not going well, they kind of look at me and I look at them, and we kind of know that it's not going well, but they generally will give you wide latitude. The court has to, because they know that this is your due diligence. This is your ethical responsibility. You've got to do it. So maybe there'll be a surprise. You never know. Barring a surprise.
You don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. and you read her the Miranda rights card, correct?
Yes, from my card.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
It's highly relevant.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is
This
that
is if
she
you
did
asked
not
me to be
waive
an
her
attorney.
rights to
But
remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. She understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the
I'm gonna use
totality
that
of the
one. Last bite at the
circumstances, whether it was
apple.
coerced or not. You can take any technique.
That's a big thing in the law. You know, you only get one bite at the apple. You can't redo something you've already tried to do before. That's a big thing in the law. They talk about remanding a case. Oh, so they get another bite in the apple. And that's why the judge, instead of saying, this is your final argument, he said, this is your last bite at the apple.
He said,
So,
wrap it up.
yeah, basically. Yeah, it's another way of saying wrap it up. Yeah.
Or a non-technique, something that you use or don't use to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say to this detective?
Keep calling the defendant by her first name.
All right.
Oh,
Can I say
please.
Sarah Boone?
Either Miss Boone or Sarah Boone, that's
Okay.
fine.
Is that
What a petty thing to say. What a petty thing to say. I guess there's a local rule in Orlando, Florida that says that you can't call somebody by their first name, but only by their last name. He represents her, so why can't he call her whatever he wants? I mean, in a court of law, it probably wouldn't be appropriate to call her Suitcase Sarah, which is her nickname, in the world. But I mean, come on, that's petty. That's very petty. But anyhow, so the judge overruled the objection, and he's going to allow, he's giving Attorney Owens a little bit of latitude to go ahead and keep questioning about that last sentence, which is, do you understand these rights? And understanding these rights, are you willing to give us? So that that the judge is giving him latitude, even though the judge pointed out earlier that none of the case law really allows that as an issue.
Mhm.
Let's go.
Nice, polite.
So he can't call
Demure.
he can't call his own client Sarah. He has to call her Ms. Boone. Okay. All right.
Whatever you say.
Have you had a chance to look at the
In court, you can't say whatever to the judge. You can't say that. I'll say it here, whatever.
standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I did not. Questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
That one was a little spicy. I kind of liked that one. It's like, did you know? Now I know. Well, did you update it? No, me. Yeah, he's being petty.
I can tell you what's going to happen.
When y'all
with this
took her
motion.
phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had
She needs to make up her mind because she said she listened to
Tell
all
me
her
what you
interviews, but
understood,
earlier she said she didn't.
The
listen to
conversation
the,
was as it relates to her
Mr.
getting her
Boone
phone back.
one.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection. Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection. Relevance. Work product.
Sustained.
At some point, y'all had to, were y'all working together or were you making all the calls or were y'all making joint decisions?
Objection. Relevance. Work product.
Sustained.
This man has been chewing on this apple for a hot minute
There's
right
no-
now.
there's no
Where was
pending
the
question
last
at this time,
fight?
ma'am.
Okay, thank you.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection. Relevance. Overruled.
Yes, at some point I did.
Did you make that decision by yourself or was it collectively made by others with the department?
Objection. Relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was on 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes,
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the?
Here's what's going on here. He only needs to establish a couple of things in terms of his motion to suppress the video. That's why we're here. I think in his mind, he's already realized he's lost that. I think in his mind, Attorney Owens realizes he's lost that. He's stretching out these little details. When did you form that opinion? Did you form an opinion? When was the autopsy done? Where did you do the first statement? When did she get in the car? What, he's now creating a transcript for him to impeach this woman when she gets on the stand in the trial. He's going to have a transcript. And if she over prepares for trial and gives different details in her testimony, now he'll have impeachment material. So that's my take on what's going on here now. In his mind, he realizes he's going to lose this motion to suppress the 2-hour video of the interrogation of Sarah Boone. He's creating a transcript from which he can impeach this witness should she testify differently at trial. That's my humble opinion. Is it true? Stay
would
tuned.
this work though? Because I'm curious. because like she said, for example, earlier she was like, oh, I didn't listen to my interview with Mr. Boone or whatever, but then afterwards she's saying I listened to all my interviews. Is something like small like that able to get her impeached?
Yeah, why not? I mean, it's up to the jury to decide.
Why
whether
not?
it's up to a. I mean, if you're trying a case and you see that a witness says that it was orange, and then you find out in a previous hearing where there's a transcript they said it was blue. Okay, if they weren't telling the truth, then should the jury believe that they're telling the truth now? So yeah, credibility is always an issue. So that's my take. I might be wrong, but I think what he's doing now, I think he's realized he's lost this motion. But let's create some material for impeachment at trial. Let's see.
The autopsy?
Objection, relevance.
Custody is not disputed on the February 25th statement.
And the prosecution is having none of it. They're objecting to all this. He's objecting on the grounds of relevance. A lot of the objections have been sustained. I think the judge is probably going to lose his patience for this pretty soon. But like I said before, he's probably giving Attorney Owens some latitude because Owens has got to say if there's an appeal based on ineffective assistance of counsel. He said, no, you know what? I did what I had to do. So he's doing what he's got to do. We may not like it. And I'm losing a little bit of patience here, but he's got to do what he's got to do.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I love that.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first.
Okay.
The objection sustained.
Oh,
You may proceed.
the judge is getting to the end of his rope.
Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
Objection, relevance as to what probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all that information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Judge doesn't even know
Yes,
how.
we have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection, relevance.
Overruled.
Yes. didn't
Okay.
want to show her the videos.
And you agree, in your opinion, the video, the two videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes,
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, relevance.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
the Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, "I'm going to have you sit in the green chair"?
Objection, best evidence is the recording.
That's too much.
Right.
I'm gonna have you sit in
Okay.
the green
Objection
chair.
sustained.
What if it was orange?
I told you.
Do you agree,
You were spot on.
prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Oh, that should have gone in. That's really
Do you
important.
recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
You know, what he's trying to establish here is, and the judge sustained the objection to it coming in, was that this officer indicated, "Oh, we have to talk to you." So he's trying to say that she was not free to go, although she did read most of the Miranda rights, all the Miranda rights, if you go with what the state and the judge are saying. He's trying to indicate that there was some coercion, and that if she was not read the Miranda rights, they coerced her into making the statement. That's where he's trying to go with this. If it was coerced, you know, there's an argument that the statement could be suppressed.
I
It's not
almost,
really.
I feel
not-
like, so I'm not a legal professional, obviously, with peace and love, but I kind of understand to a degree, because he's saying like they were already going to arrest her. They invited her in to interview, but she didn't know that she was going to be arrested regardless of whether or not she said anything or didn't say anything. So like I kind of get it, but also this whole thing is crazy to me. It's incomprehensible. Yeah.
And that part didn't go in. The substantive thing here, the really substantive thing here, is that they did read her the rights, which say you have a right to an attorney. If you can't afford an attorney, one will be provided for you, and that you don't have to make any statements if you want to have an attorney. So they read all that substantive stuff to her. So, well,
Oh, but she didn't get the 9th point on the card that she
Is it the
had.
policy of the Orange County Sheriff's Department to make any statements to them about
objection.
the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
Told you.
I assume that's not the first time you've read Miranda to a suspect.
Objection,
Sustained.
What the attorney Owens, Sarah Boone's attorney, is trying to establish here, and the judge has already told him twice, not only here, but in 2 hearings previous to this, that it doesn't matter what the policy is. What's important here is the constitutional law, what the constitutions of both the United States and Florida require in terms of reading Miranda rights, and whether the Miranda rights that were read to Sarah Boone were in accordance with the federal and state constitutions. And Attorney Owens keeps going down the rabbit hole of, well, was it against the policy? The judge has already told him that's a spurious argument, but here we go into the rabbit hole again.
Oh,
Go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
Is it me or does it look like she's falling asleep?
well, it's funny because I don't between just like it's interesting just seeing like her facial expressions and stuff. I mean, I'm sure she's done. I'd be over it. I mean, this whole thing is brutal to watch,
It
I
is.
can't
It's
imagine
tedious.
being there. Oh,
Tedious.
yeah.
We can't put it on double speed, but it's live, so you can't
Like,
put real life
actually.
on double speed. But I know there are people out there that instead of doing live hearings like this, they'll just like do it that night and they'll put it on double
Mhm.
speed. Because I mean, how many times have we seen the back of Sarah Boone's head? I mean,
Yeah.
I'm kind of tired of seeing it. There we are with
Mm.
the papers. We were talking about that before. There they are with all the papers that Judge didn't want on the Koberger case, but here we have them, and it's like, so what? I mean, they could be Sarah Boone scribbling.
Mhm.
You got to talk into the microphone.
That's what I was wondering. Is it the microphone? Is it her? Did they need to move her mic? I don't know how this got so messed up.
It's not mic'd well.
It's filled out by me, but there's something highlighted that I did not do.
And that form filled out as it relates to Sarah Boone.
We're talking about just this top, right? Okay, I'm sorry. Does it what?
Is that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or not?
Yes.
Did you see her sign it?
Yes.
Is that your signature or not?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On
on that form, is there also Miranda warnings?
Yes.
That is a form that's standardized by the Sheriff's Department.
Yes.
And you did not read a Miranda from those rights?
This is not
From this
mic'd
piece of
well.
paper?
Whoever set this up,
That's not
they
even
have all these
paper.
unidirectional mics right in front of people, and the witness stand mic is obviously not, it's not close enough to her, or it's not potted up enough, and they really should have unidirectional mics hanging from the ceiling to grab the audio
Same
when they're
objection
walking
to the
around.
relevance.
Mhm.
As far as it being a
Yeah.
consent to search her phone,
I'm
we're not disputing
curious
that she was in custody on
for-
February 25th,
the
2020, when
logistics.
she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response. Judge, obviously we disagree,
Well, then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state?
Not the first time the judge has said this, not the point, those cases that specifically weren't talked about, but not the first time this judge has said that. This motion is going nowhere slowly. I wish I could say this motion was going nowhere fast, but it's going nowhere slowly.
I'm like confused as to what exactly was it that was missed, because everything that was substantive about it seems to was already said. So I guess I'm curious
Well, he's
as to what
saying
the 9th
he's
was.
saying that that she didn't read the final thing. Not only do you understand each of these rights I have explained to you? Okay, she read that, but she didn't read this. Having these rights in mind, do you wish to talk to us now? But that what the judge is saying is that question number 9 that I have here, that's not referenced as being required in any of the Miranda case law. So that's why I say this case is going nowhere slowly.
Identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation.
This is tough to watch as an attorney, because if a judge, there are judges that just sit back and listen, but this is an activist judge, and he's pretty much just told Attorney Owens, you're not getting anywhere on that. That's irrelevant. What you're saying is not the law, and the facts that you're stating are irrelevant because the law is different from what your argument is. And so the judge has already told him, dude, that's a losing argument. But he keeps going on and on and on. They kind of got into this in one of the previous hearings. And so for it to come up now where, they had the judge asked them last week, give us case law, give us case law, give us case law. Case law was provided to the judge, and the judge is looking down and say, hey, what you're saying here doesn't go along with the case law you gave me. So it's difficult for me to watch this. It's tedious.
And to ensure that Sarah Boone understands her rights.
I know I'm going to get comments about that because during one of the Koberger hearings, I said something similar to that, and I got nasty comments. That's okay down here. That's okay. And we read them. Blast me, folks.
Well, I think it's appropriate
asking that
because
question,
you're
do you-
right. A lot of judges don't just say anything. A lot of judges will just sit back and then just kind of chuck it at the end. So at least he's kind of being a little bit more forthcoming.
This judge is very, very, very. He's following it along, and he's already told Owens, nuh-uh.
Mm-hmm.
You understand the rights I've just read. And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement,
And the judge
there
is like,
must
wait
be
a
a
minute,
conscious waiver of the rights.
no.
The problem with the
no.
detective is she reads the rights.
No, it's
you
not in
understand
here,
the
no.
rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed.
That is breaking news that Sarah Boone is going to testify. I mean, it has been intimated before that if she's going to bring up this battered spouse syndrome, she's going to talk to the psychologist, she's going to testify. So that's been alluded to before, but this is breaking news. This is the first time he actually pointed to Sarah Boone and said she is going to testify, and that, she's going to fry her own goose. I like to give people, in all fairness, the presumption of innocence, and of course we give that. But for her to testify, she's going to hang herself.
Usually defense doesn't testify. Usually you wouldn't want to
Rare.
put your client up for that, right?
You're right. Absolutely. It's rare. So I think we can put a headline up now that she just,
She's going to be testifying, yeah.
That question and how it ties into the case. I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights?
Did you pause?
I don't know what happened to the audio.
Is it moving for you right now?
No, it looks like it froze.
Oh,
Yeah.
what happened?
Yeah. I don't know. Maybe they lost their satellite feed.
Uh-oh.
Maybe they only bought an hour of satellite time. Maybe they only bought an hour of satellite time. And let me try the other channel. Hold on. I had two channels up here. So I bet that's what happened. Because we're more than an hour and a half into this. And maybe they only bought an hour and a half of satellite time.
What does that mean, satellite time?
Well, I mean, if you're in one place and you're beaming this up and down to a studio, the studio only bought so much time on the satellite, and the satellite's moving on. So let me try another one. Hang on. Oh, it's come back. It's coming back.
You would agree the situation.
It came back. It's dark.
On the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car.
Yes, I had more evidence.
That was without the autopsy.
Yeah, they're having satellite
That was
problems.
without the two videos from her phone in the squad car.
Yeah, I did at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Let's see, what other argument do I have here? I've been in that position. Let's see, what else? The judge is still letting me have some time. What else do I have here? Let's see. I didn't usually go into court with alternative arguments, and so he's already been told by the judge.
That's all
That
the
argument.
questions I have at this time.
Okay, that's it.
Any redirect?
Nothing.
All right, can this witness be released?
I'd like you to stay.
All right, subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
Speak into the microphone, please.
Mm-mm.
Just that one.
The question is whether the judge will rule on this now and say denied, or whether he'll take it under advisement and write up a lengthy decision and issue it sometime between now and next Monday when the trial starts. That's the question.
Such a short period of time.
What is it that's been marked as Defense Exhibit B?
Usually the court looks at something before it is marked as an exhibit. Litigators have this saying, CROW,
Any
C-R-O-W,
objection?
court,
Objection.
reporter, other side,
Is
witness.
it the form as of now, or is it the form as of 2020 when the? Okay.
So
Can I sit
for
for a moment, please?
for it to go to
Thank
the
you.
for it to go to the court reporter before the judge, that's no. That's something
Any
back-
additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same argument.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
So will there be a ruling on this motion, or will he write a decision at a later time, citing all the case law that the defense itself provided? The defense itself provided case law that apparently does not support the argument that they're making, which is not a good day. It's not a
And
good.
Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge, it's the policy of the sheriff's department.
So now Owens is up at the bench talking directly to the judge, kind of like a sidebar, but not a sidebar. And there's no microphone there, so we can't hear what's going on.
Do you know what page specifically those policies are on?
So now they're talking about the sheriff's department policies, which the judge has already said are inapplicable. It's the Constitution that's applicable.
2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
So it would appear they've put all the evidence in on this issue. The tape or the DVD of the actual 2-hour question and answer with Sarah Boone is the primary evidence. And apparently Attorney Owens is putting in some other evidence.
I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
The judge is really
It
bending
goes
over
on to the next page.
backwards to read all of these policies where he's already said that they are not relevant. He's already said that
2A on
the
14.
policies are not relevant here. What's relevant is the constitutions, plural, of the United States and Florida. Under constitutional law, a state can extend additional protections beyond the U.S. Constitution, they can't take anything away. So the U.S. Constitution is really the overriding authority here, and if Florida provides any additional protections, those are certainly pertinent. So all of the Florida courts' interpretations of the U.S. Constitution are certainly directly applicable to the issue before the court.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1.
So he's letting the evidence in. He's bending over backwards for the defense.
All that for nothing. Oh my god.
Well, that way Sarah can't appeal on that basis. Oh, the
Yeah.
judge didn't allow the evidence. Judges are allowed wide discretion on what evidence they will allow in, but this judge doesn't want to be overruled on a minor, evidentiary ruling. The judge doesn't want to be overruled.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Oh no!
Uh-oh.
Oh my!
Boone can approach the podium.
He's calling Sarah Boone. He is
She was
calling
previously sworn in.
Sarah Boone.
Woo!
Here. This is big, folks. This is your 6:00 evening news headline.
Yes, sir.
This is
And the
error.
deputy's got a mover.
This is bad call. It's a bad call. She's the one that's. This is why she's been through 8 attorneys, because the other 8 said, no, you will not testify. She said, yes, I will. This is my opinion, folks. And so he came in and she said, I want to testify. I'm going to tell the court. So here we go.
Ma'am, you've already been sworn.
Imagine.
Counselor, you may proceed.
Oh my God.
This is a bit shocking,
And would you
folks.
please state your full name?
They bent the mic.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Why didn't you tell the other girl to speak up?
Yeah, really.
And they were gonna say move the mic. She's chained
Where
up.
are you currently housed?
Jail.
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused.
Oh my god.
Very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Nah.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything?
It's not a game of 20 questions. You never want to hear a judge say that to you ever.
That got so feisty so quick.
And the problem is that it's really, it's not a rule, but it's a given that you rarely, if ever, want to put your criminal defendant on the stand, because you don't know what the other side has on them. And also your defendant might think that they're smarter than everyone else in the room.
They might
They're
excel
not.
at everything.
They're not. They're not the smartest person in the room. And the prosecution, we didn't even have to wait for the prosecution to cross-examine her. She's already making a pretty bad appearance.
Mhm.
But I think this will be law school 101 example of why you never put your criminal defendant on the stand. Let's watch.
Holy moly.
Thing in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25. Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away, I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hope Cell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection calls for she's got the-
Sustained.
We already had all of this information. We already had all of this. This was brought out by the detective.
Mhm.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Copsell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Copsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
I'm not one to say case closed, but she just said, yes, she read me my Miranda rights.
Yeah.
So what's the issue? What
I
is the
definitely agree with that.
Bad question, worse answer.
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
Anytime you're talking to police when your boyfriend is in the suitcase upstairs, you know you're a suspect.
I am very, very, very seldom, and by seldom I mean ever, talking to cops in relation to someone being dead. You would have to presume that.
Come on now.
There's a
on.
reason you're talking to them.
How can you not somewhere in one piece of gray matter think, I bet they're talking to me because they think I did it?
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
So how is that pertinent?
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time,
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay.
Oh my
At
goodness.
some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Coatsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
You're eligible for statement.
Sustained.
Could somebody in chat or anywhere bring all your friends and tell me what of relevance she said to the legal issue as to whether or not the statement should be suppressed? Would somebody please enlighten me and tell me what of relevance is any of this?
Oh my goodness. It just feels like they're making a drag. I'm surprised. Like, the whole logic of she fired all her other attorneys because they wouldn't let her do this is starting to add up right now.
Yeah, that's what I'm thinking, and I'm saying to myself, this is going to be the lead story on all the 6 o'clock news is everywhere in Florida, and they have an hour to put it together. But it's kind of like a train wreck. You got to keep watching.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
Do I need to call for a yes yes or no, she said yes, and now I don't know like what's pending and how to get it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion
think
about
they-
you being interrogated at the sheriff's department?
No.
What'd you say?
Do you think that the investigator would have actually said that?
That's in one of the previous motions, which they were
Okay.
trying to trick her. That's why she's saying they were trying to trick me. But you know what?
Uh-huh.
There's case law, and I don't agree with it, but there's case law, especially in Florida, that says it's okay for investigators to tell untruths. There's an
Mhm.
old saying, police lie. And now you and I both have extended family members who are police officers, and we're not painting with a broad brush, but there is actually case law, especially in Florida, that says it's okay for police to tell untruths. And so
Mhm.
this is a non-issue. Ms. Boone is trying to make this into an issue that they tricked her, but it's a non-issue.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
Okay.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window. And he says, no, your phone is upstairs. So we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And
So she's trying to say that they tricked her into going up to the second floor and give that statement in the second floor conference room, but that's not a valid legal offense.
Mhm.
Especially since they did, give her the Miranda rights under the Constitution. Maybe, I don't know, maybe they flubbed up under the policy, but the policy is not as important as and is overridden by the constitutional law. So I don't know.
what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you direct.
So now she's admitting that she wanted to talk to them. I don't care if there were questions. I mean, as we know from a game show, facts can be placed in the form of a question. So now she said she wanted to talk to them. She had a list of questions. And if we fast forward, she did ask a bunch of questions. So now she's admitting that she voluntarily, I mean, I could write the judge's order. He's probably writing it right now. But
Mhm.
directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
And she also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way,
Were you trying to cooperate?
in every way,
Were you polite with them?
very.
And when
But that cuts both ways. I mean, she wanted to talk to them. She wanted to speak to them. She was very polite. She wasn't combative. She didn't fight to say, I want to get out of this room. I want to leave right now. No, this isn't really, I know where they're trying to go with this, but this argument is not helping her. This is not helping her at all.
when she said that, we just have to do it, you said, just like we did yesterday. And then you said normal protocol.
Yes,
Is that what she had said the day before?
what do you mean?
Normal protocol.
Yes,
Had she said the same word? Could you said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes,
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
But the judge has already stated that the case law doesn't support this as an argument. So this is a waste of everyone's time. This is just, and I know I'm going to get bad comments about that, but I mean, the judge has stated that you guys have presented me with the case law. I've read all the case law, and this argument that they didn't ask her this particular question, number 7 or number 9, I forget now. That's not a valid argument. So this is a waste of time. And I think to answer your question, Majestic, I think the prosecution is limiting its objections here because they know that Sarah is damaging her case. She's doing damage to her case. I think she knows it now. Look at her. I think she knows it. I think she realizes her demeanor is not the same as it has been in the motion hearings. The motion hearings, she's been a lot more aggressive. She's just sitting there very passively.
She got what she wanted and realized it wasn't good.
Yeah, and the judge is, I hate it when people try and read my expressions.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was
So
in
what?
custody.
What does her subjective perception matter?
The judge said it more articulately than I did.
Under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to
she was
whether or
being
not.
questioned- She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes
He's like, what
subjectively
are
to
you
her and
fighting
what she was
for?
feeling, if she had a free choice or not, based on
What's the subjectivity matter?
excuse me, based on
What's the subjectivity matter under the case law?
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
I think she knows she made a mistake.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
It means you're drunk.
And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? You consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
This is why you don't put the defendant on the stand.
Now or then?
Then,
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Your Honor, instruct the witness to answer the question, please.
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
Humana.
She said she didn't know what it.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
regarding the-
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
He doesn't even get a break to collect his thoughts. After all of that, after we've been here for 2 hours and 20 minutes, and so, you know, he's trying to put it together. He's shuffling his papers and his tablets, and this is going to be a tough one to argue because the judge isn't buying it. The judge is not buying it. He's not buying any of it.
And she also kind of just admitted to her own bias there, kind of.
It's my understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact.
Okay.
We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances.
Attorney Myers, do you think that Sarah should take a plea it down to like 21, 22 years, or should she go forward with a trial, which she's going to lose and she might get life? That's my question to myself. It was a rhetorical question. I think you know the answer.
Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques.
This is all true. It's horrible law, but it's the law. And as lawyers, we have to observe that law. So what he's saying is laws, cops under Florida law and law elsewhere are allowed to lie. It's horrible.
It's kind of crazy. It's a little scary.
It is scary, but, you know, it's the law. But Sarah had every right to say, I don't want to talk to you guys. I'm out of here.
Mm-hmm.
When it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant. It can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights.
Which
you
they
have a
did.
right to remain silent.
Which Sarah should have.
But within a minute before, the detective is telling Sarah Boone, we have to do this.
So?
We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event. She lost her boyfriend.
She
I'm
killed
coming to
him.
get my phone. I've been tricked into coming up here to get my phone.
She went there voluntarily.
And I'm sitting here having to figure out what to do about whether to talk to these people or not.
No, she had
And
questions.
she's
She
talking
wa-
about my rights, but then saying, we have to talk to you.
She said that she had questions. She had a list of questions that
She had a
she went in
whole
there.
list.
She wanted to ask them. So this argument isn't really in conformity with the facts. But that, we're all allowed to argue stuff.
We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be.
Hi, Darlene. Darlene Danielle, a very, very, very good attorney in Southern New Hampshire, has joined us. Darlene, thank you for joining us.
Hello, thank you.
It's kind of crazy, isn't it?
A valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses.
Was it really false pretenses, though? She said that she had a list of questions that she wanted to ask them.
Coupled with the fact she doesn't have the 9th question.
Which the judge has already said is not relevant in any of the case law that was provided by either attorney.
If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questions. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kupsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kupsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kupsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record?
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, I just want clarification, but you know, she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk.
Laney Law, you were out of the room, but they finished up all their arguments on the issue as to whether or not that 2-hour statement will be repressed. The judge says he'll write it. The court's closed for some holiday tomorrow, which I don't know what it is, but must be St. Swithin's Day in Florida. I don't know. But anyhow, the judge says he'll be in all day writing the decision. He'll post the decision on the motion to suppress by the end of the day tomorrow. But now they've moved on to makeup, hair, and restraints. So the judge said the security people say, okay, there won't be any handcuffs, so she'll be able to write. But now they're arguing whether or not she should have leg restraints. And her attorney, Mr. Owens, is arguing that she's closest to the jury, and if they see any restraints, that impinges upon their perception and therefore her right to a presumption of innocence. So that's what's going on right now.
I also want to add that I think it's a little obviously we recently talked about a case where someone decided to make a jump or run for it, but realistically, if she is not restrained, are they implying the security isn't going to be able to take her on? Basically, I don't know about that.
Yeah, that was that guy earlier in the year. Remember that guy earlier in the year? Big guy that vaulted right for the judge and actually somersaulted over the bench and did some damage to her. So, courts courts legitimately have a right to security, but I mean,
Yeah.
put a couple of bailiffs in there and they can.
Yeah.
People have said a lot of things about Sarah Boone. I can't see her pulling that off, but you never know. So that's
Just
That's
keep the
the
suitcases away and they'll be fine.
funny.
We believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny as she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe so.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a
Can I
person
ask
come
a
in there to
question
take
real
her
quick?
measurements. They may have to
Wait
be
a minute.
with you, counselor, in order to facilitate that.
Yeah, what's the question?
Who's paying for these clothes? Is the implication that she's paying for her own clothing?
Yeah.
Okay.
Yeah. Well, that's a good question. The court is not going to pay for them. She can have
Yeah.
clothing provided to her. I mean, I don't know. She apparently stayed the night of George Torres's demise, the night after that, with her ex-husband. So one has to wonder, what the heck was her relationship with her ex-husband then? I mean, would he pay for it? I mean, as a defense attorney, I know I have a duty of due diligence to zealously represent my client, but I'm not going to go down to Marshall's and start buying dresses. I'm sorry.
Yeah. That's my thought with it, is just like, that's, if the attorney, like, obviously the attorney can supply it, but it sounds also weird just how they're going to get it. Anyway, sorry, that was just a little side.
I'm sure. I mean, in a case of this nature, I'm sure that'll be worked out. But the court has made it clear that the state is, paying for a lot. The state has already said, no, we're not paying for that. But the issue has not been finally resolved in a motion. That's why they're arguing it. So I don't know if they're going to get to the makeup next.
But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. It doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But
I've had a bunch of paralegals in the past. I don't know if they would want. I had a lawyer once when I was in law school and I was just a clerk. I had a lawyer once tell me to go down to the downtown and pick up his shoes at the shoemaker. I didn't work for that lawyer much longer. and he knew why. I can't see asking a paralegal to do makeup on a defendant. I don't know. I don't know. Let me know down
It's a
in the
very
comments.
sweet paralegal.
Yeah.
They're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning.
Okay, well, they already started it a half hour late, so.
Other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes.
The hair.
Yes.
The hair.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
That is having the makeup
DOC
on
and-
contraband? No.
And sheriff's officers tell me they can't do it because of the concerns that were just outlined
Take it off.
after she's returned to the Orange County Jail facility.
Better go to
Divas.
the bathroom and take it off in that bathroom for God's sake.
Yeah, and micellar water and a cotton round, 5 seconds. Seriously, and even then, it's like women who are in prison find all types of shady ways to do their own makeup anyway. Like, is the makeup having makeup? I would assume having the actual physical products is the contraband, not the having it on your face. It's like if you tattoo yourself in prison, what are they going to do? Remove the tattoo? Like, it's.
I mean, how hard would it be to just let her go in the bathroom? There's got to be a female guard or bailiff that can go in the bathroom and watch while somebody puts makeup on real quick. Not that I'm an expert at any of that, but I mean, go to the bathroom, put the stuff on, and then in the end of the day, go to the bathroom and whoosh, take it off. I mean, I don't know. I don't have a dog in the fight, just like the other guys just said. Just like I don't have a dog in the fight. I really don't care, but I can't believe they're wasting time at 5:45 in the evening about this.
That's like out of all the things to argue about in the courtroom, the makeup is something so minuscule and
Yeah, let her have it. Now, I mean, some cheap Walmart makeup. We're not talking about going to the cosmetics counter at some, she place in Manhattan. No, we're talking about Walmart makeup. Come on.
yeah.
You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need more.
What about
I
the
need to
hair?
understand what you're looking.
What about the hair? I thought there was also a motion. I thought for her to have a hairstylist do her hair.
I think they're
Did they
giving up
skip
on
that?
that. The makeup's already so hard.
Really?
At Mr. Owens with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for I guess that was filed on Monday, forgive me, had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
to whether or not it was a
if it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I believe, I mean,
Can I ask
the
something real
state
quick?
has just been
Because
dropped with her medical
Wait a
records
minute.
that investigate.
Yeah.
they were saying that he can try to get the documents and submit them into evidence. The case is next week. How much time do they have for evidence?
Yeah, well, this attorney is just raising a storm. He's just raising a storm and trying to get as much in as he can. You know, the court, I think erroneously, but strike that comment. The court said that they are going to be allowed to use the battered spouse syndrome, which is a misnomer because George Torres and Sarah Boone were not married, but the court allowed that to come in. And so part of that is somehow the defense is going to have to get evidence in of past bad acts. And so apparently they've subpoenaed, social workers and court workers and victim advocates, and those people are protected by all kinds of privileges. So, it's an unusual issue, but Sarah Boone has got to bring in some kind of evidence. She can't, just bringing in evidence of her own fear is not going to cut it with the court. So I don't know if that answers your question or not.
I'm just surprised that they're able to go back and forth about the evidence so close to the trial date. I know that this is a new attorney and this is a new argument that they're presenting, but I was just surprised to hear him say that.
Yeah, no, you're right. You're absolutely right. And in a normal case, in a normal day, a judge would be furious. A judge would be furious about these issues coming in less than a week from the trial date. But with a new defense attorney coming in just a month ago, he's going to try and get away with as much as he can. That's what it is. He's trying to get away with as much as he can in his due diligence. And will it work? Well, we'll see what the judge says.
Everybody's being very nice to each other.
Even though they keep on saying in their amended discovery exhibits they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
Yeah, but if they don't have a witness.
Order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon. It appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, Paul's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion.
The audio is so inconsistent in the court.
Yeah, that's because they don't have the pool overhead mics. They just have mics at the tables.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone, moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you can favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
So that's it. It was almost a 3-hour hearing. Well, actually, they came out late, so we're going to say about a 2-hour and 45-minute hearing.
Yeah.
But that's it. It went on. It started late, but it went almost. It's 5:57. We delayed it a little bit from our stops. We did stop the motion so we could talk a couple of times. But so that's it. And Sarah is, she's wearing her handcuffs. She's going to be taken out of the court right now. I guess she's going to be given a minute to talk to her attorney, but that's pretty much it.
So the judge could have theoretically been like, he could have just let them know that that whole first argument wasn't going to fly with, being the Miranda rights. Like, he said that he's going to be working up on writing that all out, but theoretically he could have just said, guys, no.
I've argued motions where the judge has said had just right in front of you denied or allowed. And then move on. But I've had that happen to me, and you move on. Once the argument's done, and they can do what they want to do. But again, this is a case that if she is given life in prison, there will be an appeal, and so everything that he does is going to be in the crosshairs of an appeals judge. So he doesn't want to just say denied. He's going to come in tomorrow. It's some kind of a holiday in Florida. I don't know what kind of a holiday it would be.
I know they've mentioned that a couple times. Yeah. I looked at my calendar. I need to Google this. I looked at my calendar and I couldn't find it.
Florida must have some kind of special holiday. I mean, I know in Massachusetts we have that Bunker Hill Day that I had never heard of before I moved to Massachusetts all those many years ago. New Hampshire has a couple of, every state has its own little holidays. So maybe it's, I don't know. Maybe, I wonder if it has anything to do with the hurricane, Helene, that they have to have a day to recognize the victim. I mean, I have no idea. Idea. Maybe it's the day Ponce de Leon landed on Key West and said, I've been here. No. I don't while you're looking that up, October 3rd. Anyhow, so the judge says he's going to come in. He's going to
Augustine Celtic Music. I don't know. I'm not finding a lot. I don't know why the court's closed.
Maybe it's just the courts around here will have a day where they close for continuing legal education, either by the judges.
Rosh Hashanah.
It's Rosh Hashanah. I should have known that.
Yeah, I took a lot of steps to get to Rosh Hashanah. I had to do a lot of.
And I knew that from hearing the news this morning. I heard that from hearing the news this morning. They were talking about Rosh. I should have known that. So I apologize to our.
We appreciate our Jewish viewers. We love you. Happy Rosh Hashanah. But also, I am shocked that the court is closed on Rosh Hashanah. Which, shout out, more holidays the better. But and the kind, sweet judge is going to be writing all day tomorrow.
My colleague Darlene Danielle asked us a question. What about good lighting and a good filter? I think that you're being slightly sarcastic, Darlene. I mean, really.
I say, honestly though, like I'd be a little devastated to find out that I'd be going to court all these days with no makeup.
What about like they have consultants now. They have consultants now that they look at your skin tone and your eye color and your hair color, and then they give you advice as to what to wear. Now, shouldn't she have that too? Somebody to come in and decide what her based on her skin tone
the
and her
skin
hair
tone
color.
swatch.
What I mean, they're not going to just go down to Marshalls and buy some off the shelf dress for her, are they? I mean,
We
Anyway,
have to
the
be
judge-
fitted to the nines despite the crime.
So-
No, I kid, but I feel like, as silly as it sounds, it's at the same time, I feel like makeup at least is not so serious. And put a couple cat ear filters on them too, whatever.
cat ear filters. I'm certain that the attorney Danielle was being slightly sarcastic. I have to assume that. She has a
Not
good
100%
sense of humor.
seriously.
Very good, very serious attorney. But even people like her have a sense of humor. Anyway, okay, all right. So finishing up our recap, the main issue today was whether or not that 2-hour statement that Sarah Boone had made the day after George Torres was found in a suitcase in her apartment. They want to strike that. They want to suppress that. So the judge will, in fact, have to come in tomorrow on Rosh Hashanah and write a decision on that. And again, like I said before, he's going to be in the crosshairs of an appeals court if and when, and I don't mind saying that, if and when she's convicted. So he can't just say denied. He's a thorough judge, obviously. He has his eye on the ball of the law. So that he wants to write a thoroughly researched and documented and citation to authority motion decision, and then he'll write his, also he'll write something up on the street clothes, which I think was already decided, on the no handcuffs, but probably the shackles on her ankles, the makeup and the hair, and so that'll all be written tomorrow, and I'm sure that that will happen. And I'm not going to say we're going to do a live on that, but we'll talk about it in some future edition. So I just have to comment. I can't see, and please comment down below. But I can't see that. Oops. I'm trying to run something here and it's not working. I'm trying to talk and do something at the same time, and that's never good.
There you go.
I can't see that anything was gained by putting her on the stand.
She must have wanted that. She was the one that wanted that. They were, I think, just trying to appease her because that was a disaster. That was chaotic. That made no sense. That she incriminated herself more than helped herself, in my opinion.
She said nothing at all that was pertinent to the issue that was before the court.
Other than that, she got rid of Miranda rights. It's like that. You get rid of your Miranda rights. Yes. Oh, I guess we're done.
So that was a mistake. And so it seems to me that that's why she went through 8 attorneys. She wants the control of the whole thing. And she told the attorney, I want to testify. And they're like, no, do not go in the stand. You're going to step on your own feet. So
well, she got what she wanted. She's getting her fair trial. Honestly, what a great attorney to let her do that, to say, you know what, you want to talk, go talk.
Yeah, so that was a mistake. And if she's going to testify at her own trial, I don't give odds, but I give a 99.999999999% chance of a conviction in this case. It's just, she's not going to. I mean, look at Alex Murdoch's trial. It was going badly to begin with. It was going very badly to begin with, but then he went on the stand. And he shot himself in the foot. I was lying then. I'm not lying now. I got off the drugs and I'm not lying, but I lied. Juries don't like that because jurors' primary job is to assess the credibility of all the evidence, the witnesses, the evidence, all the rest. And yeah, there were all kinds of comments about how SLED, South Carolina Law Enforcement Division, had made mistakes, and they did make mistakes in the investigation of that case. But Creighton Waters fantastic attorney with a huge team of good attorneys. You know, they did a fantastic job overcoming that. But if the case hadn't already been decided when Alex Murdoch went on the trial and said, "I lied," it was decided at that moment. In my mind, that's my opinion.
Yeah, well, I think unfortunately, a big part of being in court, like you said, the jury's supposed to determine like how true people are and stuff like that. And it doesn't help if you're not very charismatic, if you're not if you don't give them a reason to like you. And Sarah, hopefully for her defense, will not be going back up.
Plus, this was only a teeny tiny little view of one little teeny tiny issue. The one issue as to the motion to suppress and whether or not she had been Mirandized. Easy issue.
Small, easy.
Now, you go to the whole trial, going through the whole thing. You know, Sarah, you were laying there drunk, weren't you? Well, I don't understand what you mean by drunk. Oh, come on. Every nitwit knows what it's like what drunk, even a kid who sees their
said
parents.
She was hungover, so I was hungover. I was a little confused.
Sarah, it's true that you knew that George was having trouble breathing, and he asked you to let him out of the suitcase, don't you? Well, no, I don't understand your question. Jury's not going to listen to that. Jury's not going to. Okay,
You might as well have just said, like, that's not my phone. That wasn't my phone. I didn't take that video. I don't know who that is.
And I think a succession of attorneys, including our current attorney, when James Owens first took the case, he said he was going to talk to her and see if he could work out a plea. I think all the other attorneys said, look, if we can get him down to 22 years, which is the minimum, take the plea. But of course, it's not the attorney's. Attorney can give advice, but clients don't have to listen to the attorney. So I'm betting, and I don't know, it's only my opinion, but I'm betting that a succession of attorneys have said, Sarah, your goose is cooked. Take a plea of 22 years. You're only 47 now. So with good behavior, you'll get out right about retirement age, and you'll be able to enjoy your old age. No, she wants a trial, and it's possible. Who knows what this judge is thinking? But he seems like a pretty tough, fair judge. She could get life.
This is out of all the courtrooms and all the cases that we've been watching. This judge seems very reasonable. He seems willing to let them talk right now. So it's funny to see how. Oh God, it's gonna be a trip to see the direction that this goes in. If she's already trying to speak up for herself and seemingly that's what she wants. Oh boy.
All right. Well, it's 6:00 now. My poor dog is home pacing around. Where is he? I'm hungry and I have to go out too. So to save my rug, the sanctity of my rug.
Yeah, thank you guys so much for watching. My guy was in the crate for most of it. I went off for a second to release him. So Lily is waiting for some cuddles too. So
Lily's home. Lily is at home and she wants her dinner and she wants to go outside. So for that reason, do you have any closing thoughts? For that reason, and that reason alone.
Thank you guys. I appreciate everybody who came to the live. It was a lot of fun. You guys cracked me up. I had to mute myself because chat was making me laugh so much. I was very surprised to see how this went. It didn't go how I expected it to go.
No, me neither.
Yeah, for that I am looking forward to to see what else happens with that, because my jaw was on the ground.
I thought it was going to be very quick. I thought it was going to be 20 minutes.
We were thinking an hour originally. Oh my God.
I thought it was going to be a quick kind of a thing, but okay. Thank you, everyone. Thank you, Lainey. Thank you, everybody, for bearing with us. And, we'll provide updates when we can, but this will be all over the news. This is all over the 6:00 news tonight that Sarah Boone testified in her case. So, all right, folks, time to go to the grocery store. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.